Archiving started.
Good morning, everyone. Welcome to Chapter 2, Medical Law and Ethics. Sorry for that noise. First thing we'll discuss are the fundamental processes that our government employs. We have the federal system, which is the power that is divided between the federal government in Washington and then the smaller state offices in all 50 states. The checks and balances are designed so that no single branch of government could control the entire government. It means that every branch is scrutinized by other branches. As you know, we oftentimes have things that are on TV where a bunch of senators get before a committee and people have to go and testify under oath. The legal system is based on the United States Constitution. We have the several branches, the legislative, executive, and judicial branch. The legislative branch is the House of Representatives, and it is where all laws originate, lawmaking body, if you will. Any law that is presented there gets voted there first. The executive branch is, of course, the President of the United States, the cabinet and his or her advisors, and it's their job to enforce the law. The judicial branch are the judges and federal courts, and they interpret the law. Of course, the highest judicial branch in the United States is the Supreme Court. This is a figure, if you will. I think you'll find it in your book also, and it kind of shows the branches of government. We've got the Constitution, which is where everything has begun. We have the legislative, as I mentioned, executive and judicial branches. The legislative branch is the Congress, and it consists of the Senate and the House of Representatives. The Senate is always a certain amount. It's 2 senators from every state, no matter how big or small the state is. And then there is the House of Representatives. There are 435 members elected from the states, and it goes according to population how many representatives will be from each state. The executive branch, as I said, is the President of the United States, the cabinet, and then other agencies that are under the president. The judicial branch is the Supreme Court, and under the Supreme Court, we have district courts in every state, and then, of course, there's the Circuit Court of Appeals. It's kind of interesting, but it's, to date, the best way we know to govern a group of people. So, moving on, we have the sources of law, constitutional law, and then statutory regulatory law, statutory and regulatory law. The constitutional law addresses what happens between individuals and their government. Statutory and regulatory law is passed by the legislative bodies in either Congress or the state legislature, which would be the House of Representatives. Moving on, we have common or case law. This is established from different court decisions. It's based on precedent. Any old case decisions still influence today's healthcare professionals. There are law books yay thick where people can go back, lawyers and other people law students can go back and refer to all of the different cases that happened previously to see if a precedent has been set. There are classifications of laws, whether it's private or civil or public. The private or civil would result in torts, contracts, property, inheritance, family, or corporate law. Criminal, administrative, constitutional, and international is public. Let's go into that a little bit. Civil or private law concerns any relationship between individuals, whether they are business related or government related. When that case is eventually settled, it usually will result in a monetary damage, and whoever wins will either pay or be free from paying. And it includes court and contract law. So what is tort law? This is something you're going to be working with a lot this quarter. Tort law is a civil injury or a wrongful act. It is committed against another person or property, results in harm, and depending upon the level of harm, depending upon the level of harm, it can be international or intentional. Or unintentional, pardon me. Let's talk a minute about intentional tort, and then we'll go into unintentional tort. Intentional tort are things like assault, battery, false imprisonment, defamation of character like slander or libel, fraud or embezzlement, invasion of privacy. What are they? Assault, threat of bodily harm. Battery is the actual bodily harm. False imprisonment is violation of one's liberty. Defamation of character can be written or spoken. Fraud, such as embezzlement, deceitful practice. Invasion of privacy, break in confidentiality. And we certainly are going to be talking about that so very much this quarter. So what's unintentional? Negligence. It means that someone really didn't intend to cause harm, but when a person's actions fail to perform an action that a reasonable person would have committed or not have committed in a similar situation, it is called negligence, and it is considered an unintentional action. Some of the things can be performing carelessly or failing to perform a task, either doing or not doing something, but it's done performing it not up to standard. And again, that would be judged by precedent. So what is contract law? Addresses a breach or neglect of a legally binding agreement between two parties, and it can be either spoken, written, or intended. And again, we will go into that a little bit further in subsequent slides. But what is a contract? For definition's sake, a voluntary agreement between two parties with the intent of benefiting each other. Something of value is usually considered here, and both parties have to be competent in order to enter into a contract. So, as I had mentioned a minute ago, express contract. Agreement entered into orally or in writing, and it has to be very clearly stated. Implied shows that someone wants something to be done through inferred sign, action, or inaction, or even silence. A good example of this would be if you go to draw someone's blood and they put their arm out for you. This is an implied contract that it's okay to go ahead. If they go like this, no, or I don't want it, or shaking their head, that means I don't think so. You better not move forward with it. and that would be breaking a contract, and it could be means for a lawsuit. And a little bit more about contracts: abandonment, breach of contract. Abandonment is withdrawing medical care without providing sufficient notice. There is a standard way of doing this, which is usually by written or typewritten, not an email letter with a return receipt requested, signed notice that it has been accepted by the person to whom it was intended, stating that in X amount of time I will no longer be caring for you. Here's a list perhaps of other doctors in your area that might be willing to see you, and you have 10 days in which to do it, or something like that. But there's a specific amount of time. It's not cut and dry that it's this day, no notice, done. That would be considered abandonment. Another way abandonment would be considered as if a doctor were to go on vacation. Let's say you have a neurosurgeon who goes on vacation and leaves a podiatrist to cover his call. Well, the podiatrist can't do neurosurgery. So even though it's a physician, wouldn't count. Has to be someone of like training to cover when a person is no longer or not available for a specific amount of time. Breach of contract: either party fails to comply with the terms of the agreement. We've all seen this happening at one point or another. And one thing that I had mentioned a minute ago about abandonment: withdrawal of medical care from a professional without giving them sufficient notice, specifically in writing. And the only way you can prove that is if you mail it registered with a return receipt requested, saying, yeah, they accepted it, they got it on such and such a date. Class action lawsuit is when a group of people file, well, the attorney actually will file a lawsuit based on a larger group of people that are complaining about the same thing. They are all affected by the same situation, and everyone will benefit from the settlement, should there be one. Now, public or criminal law protects the public from any harmful act of others, and it says any socially intolerable conduct that occurs is definitely punishable by law. The government will prosecute the person or the institute that violates the law, and it can be considered either a felony or a misdemeanor. It may result in a fine or perhaps a misdemeanor, imprisonment if it's a felony, or it could result in both, depending upon the level of the infraction. Now, administrative law. A lot to know. These are the regulations that are set by the government agencies, and it has to do with the licensing and supervision of prescribing controlled substances. Now, the physicians are given a number, a DEA number, so that they can prescribe a controlled substance. And they're basically the only ones. It's any health regulation that goes through the court circuit is considered administrative law, and any regulation against homicide, infanticide, euthanasia, assault and battery are considered administrative law. Homicide, of course, is murder. Infanticide is the killing of a child. Euthanasia is death, aiding and assisting death, which is not allowed in most states. There are 4 states that do allow physician-assisted suicide, but most do not. And then, of course, assault and battery. There are regulations against fraud, as one would expect. So, moving on down, let's talk about the court system. There are, of course, 2 systems in the United States. There's the state and the federal, and each one of them has their own specific responsibilities. They are exclusive to that area. The state is exclusive with their responsibilities, and the federal also. Both courts have power to hear the case at the same time, however. It really will depend on exactly what infraction was committed. There is another PowerPoint slide here that explains this a little bit more fully. We have the legislative branch, which I had mentioned is the House of Representatives. Depending upon the size of the state, it depends on how many are elected. It's a 2-year term, and the Senate, of course, is just strictly 100, 2 from each state elected, and it's a 6-year term. And what happens here, and you can go all the way down if I follow these arrows, proposing amendments to overrule judicial decisions, can impeach or remove judges, and it is also, of course, establishes the number of judges and in the lower courts. That's the legislative branch. They also declare laws unconstitutional. And it all stems. You can see these arrows as they're pointing can be heard by both sides. We've got the legislative and the executive. Legislative, which was the House of Representatives and the Senate, and the executive, which is the president, the 4-year term in the cabinet. It all comes down. The executive appoints the federal judges and can pardon or reprieve a federal offender, can declare laws or acts by executive branch, and can call them unconstitutional, and then that goes to the judicial or the Supreme Court. They can also do the same thing all the way on up. In the center of the whole deal, I find pretty interesting because either the legislative branch right here or the executive branch here can overrule the president's vetoes. If the president doesn't like something that's done, they have that little stamp saying, I'm going to veto it. But the legislative and the executive can can overrule the president's veto. Pretty cool, huh? They refuse treaties, perhaps, refuse to confirm a federal official appointment. Big one here, impeaches or removes the president. Refuses to appropriate money for an executive program that the president or the cabinet has asked for. Can you remember back the only time in history that we were alive where a president was almost impeached? Another thing they can do here in the center, either branch can veto bills, call special sessions of the Congress, and they control appointments, certain appointments to offices. This is a great slide. I think I've seen this in my high school civics class, and then I've seen it again many times in studying other different law and ethics types of situations. But anyone who ever wanted to know what the United States government does and how they operate, this is perfect. So let's go down to the types of courts. We've got the federal and the state. The federal is a municipal or a district court. We've got a circuit court of appeals, and then we have the United States Supreme Court. Those are the federal. The state is the district, state court of appeals, and then the state Supreme Court. The federal court structure starts up top with the United States Supreme Court, and because this is how a potential lawsuit could start at the bottom and then slowly go up the stairs and move up right to the Supreme Court. Let's say we start out with tax court. Administrative agencies can talk about it. It can go to a district court, and then the district court would send it to the Court of Appeals, district-wide, all the way to the Supreme Court. Supreme Court can decide whether to hear it or not hear it. On the other side, we've got a claims court. It can go to the Merit System Protection Board. It can go to international trade or the appeals for a federal circuit court system, again, up to the United States Supreme Court. There's a lot to know. So, we've got civil law, the things that are considered civil law. Tort, contract, property, inheritance, family, and corporate. We are going to be doing a lot of work on tort law and contract, mostly tort though. We will be talking about under tort, negligence and malpractice and non-intentional. Notice that the contract, property, inheritance, family, and corporate don't have to deal with the negligence right there. But down beneath tort again, we've got the intentional tort. False imprisonment, defamation of character, slander, libel, assault, battery, fraud, and invasion of privacy. Now, which ones do you think we'll talk about medically? Certainly the negligence, malpractice, and non-intentional. We will talk about maybe defamation of character and slander and libel, assault, battery, and that's about it. I don't really want to talk about maybe invasion of privacy too. Yes, of course, because that can be a HIPAA infraction where information has been passed on and it was not supposed to be. All right. This is how a federal case would be processed. Let's say a crime is committed. The police will investigate, and it depends on the infraction. They may have an attorney right away that will be seeing, the people that are involved. It may go to an indictment by the grand jury saying there's enough here that this has got to go further. If we went to an indictment by the grand jury, the defendant appears before the judge, and there's a pretrial motion, a trial, and then they are either guilty or acquitted. And they get sentenced, etc. That's what happens with the indictment by a grand jury. On the, let me get rid of that. On the other side, we've got the crime, police investigation, prosecuting attorney files information. Then there's an arraignment before the judge where the person will plead guilty or not guilty. At that point, there's motions, of course. Charges may be dropped or dismissed. The plaintiff pleads guilty, perhaps. It can go to sentencing if he's guilty or she's guilty. If there's innocence, it goes to a trial, and then it's either guilty or acquitted. It may then go, if the person is guilty, to the Court of Appeals. And a person could either be imprisoned or paroled at that point, or they can, go completely free. It looks quite difficult to think about, but really and truly, there are so many reasons to think this is the best system in the world to give a person adequate time to appear before their attorney, judges, an appellate court, and whatever it takes in order to determine their guilt or innocence. And really, in our society, a person is innocent until proven guilty. It is not that way in every society. The misdemeanor process would be things like a traffic citation, police arrest, citation, citizen information. There would be an attorney, of course, and it goes to the municipal or district court arraignment. If a person pleads not guilty, there is a mandatory appearance, and there can be a trial by judge or jury, and they can be guilty, of course, or not guilty. If they're not guilty, the charge is dismissed and they walk. If they're guilty, it goes to sentencing, probation, and or prison time or a fine, and then if they do nothing else, the case is closed. However, if they want to go further, they can go to an appeal, and then they go to the District Court of Appeals. If they were, let me go back for a minute up top here, if they've done something wrong and they plead guilty, but they also flee and their bail is lost, that negates the trial and they go right to sentencing. Okay, aren't these helpful? All right, the trial process. The grand jury, it's usually behind closed doors, and it consists of anywhere between 12 and 23 private citizens. They hear all of the evidence about the case, and they decide whether or not the case is worthy of a court hearing. And it's kind of a filter to say, we can't hear everything, we're going to hear the most important ones. They vote on whether or not to move the indictment to a trial, towards a trial. The procedure is litigation. When two parties are unable to solve any kind of a dispute by themselves, they sue each other. There's a plaintiff and a defendant. The plaintiff is the person or institution who brings the action, and the defendant is the person or institution who is being sued. For procedure, they can settle out of court when both of the attorneys for either side work out a settlement, which the judges love to hear, so it frees up the court system. It can be waived when both parties give up the right to a jury trial, or it can actually go to trial, which will always begin with opening statements made by the attorneys from each side. It then goes to the presentation of the evidence and goes to, finally, the closing argument, where the attorneys for the plaintiff and the defendant make closing speeches, and they summarize everything that is presented within that case. Depending upon the result of the jury's verdict, it can go to appeal. The plaintiff or the defendant may ask for an appeal for a higher court to review the decision. Again, this is another idea for you to look at, or not an idea, a slide for you to look at what happens if the case is settled without a trial. Okay, there are pretrial matters that are heard. The plaintiff prepares a complaint and files it with the court that he's supposed to apply it to. The defendant is summoned to court. With this pretrial, the defendant attorney files an answer, and at this point, a settlement may or may not be reached, depending upon the weight of the evidence. A trial date may be set, and then the case is heard by either a judge alone or a jury, which is comprised of 6 to 12 jurors. Depending upon the result of the verdict in the trial, it can go to the Court of Appeals. And again, that is still not the end. Either party may want to go further and take it to the Supreme Court. And it can go to the Supreme Court in the state and perhaps to the federal Supreme Court, which is really taking it all the way. And none of this is inexpensive, by the way. The summary judgment. Request is made by an attorney, will take place in a civil trial, and at this point the court judge has said that there's no need for a trial. Based on precedent, can you please make a judgment in this case? It means that neither the plaintiff nor the defendant, is entitled to win based on the existing law. Okay, so what happens if somebody is subpoenaed to court? All right, if a subpoena, it means it is settled on someone. It means that a person or information has to be submitted. It sometimes occurs during discovery, and this is where the attorneys have to find out which facts are important to have for the prosecution or the defending of this case. So information may be subpoenaed. A deposition is an oral testimony taken under oath before an officer of the court, meaning a lawyer. And there's a court stenographer there typing every little thing that's said. This is done quite often. Now, here's something that you need to know. Subpoena duces tecum. It is a court order to appear in court and bring records. Now, one thing you should know, it does not mean bring all the records. It means bring only the records that are asked for on a specific area, in a specific area, and it may even give you dates from such and such a time to such and such a time. Bring those records that are pertinent to this particular case. Standards of proof, there are several levels that are required. For a civil case, it looks like the preponderance of evidence. That's a big word, preponderance. It means an overwhelming amount of evidence says this is it. It's almost impossible for it to be any other way. Civil cases place evidence on whatever is more credible and convincing. That's for civil. Criminal case needs proof beyond a reasonable doubt. Beyond a reasonable doubt. If you can't prove it beyond a reasonable doubt, the person must be found innocent. Now, what's an expert witness? A person who has special knowledge or experience in a particular area, assists jury or judge in determining accuracy in certain facts in the case, and can often testify to what standard of care is in that particular area. They usually paid a fee, and they clarify points of knowledge if the judge or the jury may not understand the ins and outs of a particular area. And lastly, testifying in court, the most important thing, because you're under oath at all times, is to tell the truth. Be professional, remain calm. Do not answer a question that you don't understand. It's okay to ask for it to be repeated or explained. Present only the facts. In other words, do not offer anything for which you are not asked, and do not memorize your testimony. Do it as it comes up, one question at a time. I hope you found this helpful, and I look forward to hearing from you. Take care. Have an excellent day.